to how to create an ideal employee handbook. This is a re-recording of our webinar from November when we had technical difficulties recording it. So we'll start out this morning with our usual disclaimer. The content of this webinar is provided solely for informational purposes. The information should not be relied upon as a substitute for legal, accounting, tax, or other professional advice. We'll start out today with our source material, where we received the information from. Department of Fair Employment and Housing, How to Create Employee Handbooks by Lonnie Giamella, Fisher and Phillips, which did a PIRA seminar in the summer. ThinkHR's Employee Handbook Builder, and the Society of Human Resource Management. The agenda today is to understand the benefit of maintaining an up-to-date employee handbook, identify potentially problematic policies and how to correct them, and learn the essential components to build an ideal employee handbook. It's important to have an employee handbook for a number of reasons. The first of which is to minimize your risk of employment liability. If you clearly communicate your policies, procedures to your employees, there's a decreased chance of litigation. Or if you go to trial and you have litigation, a properly drafted handbook can help you reduce liability in the case of a lawsuit. It's also a great tool to introduce employees to the company and establish expectations. It gives you an opportunity to talk about your company vision, what you do, your culture, what you're about, in an easy format as you're onboarding new employees. Some considerations in preparing your handbook is, do you have a current handbook, and should you update it? Who should prepare the handbook? There's three ways really of preparing employee handbooks, and they have different price points. The first is by using an employment law firm, a labor lawyer. Usually costs around $2,000, give or take a couple hundred. The other fee is an HR consultant, and HR consultants can usually create handbooks in the neighborhood of $1,500. There's two types of HR consultants, but the important one for you guys to use would be somebody who's certified by either the Society of Human Resource Management, SHRM, or the Human Resource Institute, which are the two bodies that certify HR consultants. And the last is using employee handbook software. There's a lot of software out there that are sort of like wizards on how to make handbooks step by step. One of the good ones is through ThinkHR, which we recommend to our clients. Prior to ThinkHR, we used to recommend the California Chamber of Commerce, HR California Handbook Builder. They're both equally good, and that's another way of going. But the Handbook Builder means that you have to know what you want and create it yourself and spend a couple hours, maybe 2 to 3 hours creating your handbook versus having somebody do it for you. So the question is, on an annual basis, do you update your handbook or do you create a new one? And that's important because, for example, in California, there's 5 to 9 changes every year that come with employee notices and posters and requirements regarding, a whole variety of areas. So sometimes you can just amend the handbook and create a new section. For example, this year coming up, 2018, there's a new parental leave law for companies with 20 to 49 employees. And you can create a whole new handbook and put that section in, or you can just amend it and say it's being added to a section of the handbook. A lot of employers mess up on multi-state operations. If you have operations in one other state or multiple states, it's a problem. We have a client in Santa Monica that has an operation with about 20 people in New York and about 60 people in Santa Monica, and they really need to have 2 separate handbooks, or one handbook that has different sections for California and New York. New York has special rules, especially regarding short-term disability that they don't have in California. And City of Santa Monica has certain rules regarding sick leave that don't pertain to New York. Another example is a client that has operations in Arizona, Nevada, and California. And they don't have a lot of employees in Nevada and Arizona. They just have a few, but there's ways around that. But you have to make sure that you're following the rules of each state, which is why you have to make sure that you handle unique local jurisdictional rules. And that pertains to even LA. The city of LA has different rules than Santa Monica, Burbank, Pasadena, Glendale. And if you have employees that work in Los Angeles, you have to have certain things in your handbook that you wouldn't have to have if you were in Bakersfield and then just had to follow California rules. So in drafting and updating employee handbooks, you have to consider who's going to look at it. And you have two audiences. One are new hires. As I mentioned earlier, it's a great onboarding process. The second is existing employees, making sure they understand the policies and procedures of your company and the updates. In the new hire process, there's certain things that aren't in the handbook that are off the handbook, so to speak. Part of it has to do with I-9 forms, HR notices and brochures that are required by California law, criminal background checks. In light of ban the box, we may have to change those, and also drug testing. So a lot of times, and I'll give you an example. Our company, Really Great Employee Benefits, we have an employee handbook, but we have a separate internet policy, a separate confidentiality policy, that when a new employee joins us, they have to execute that policy online through our HR system, and they do their I-9 and W-4 online through our system. And there's one or two other documents that they sign that are specific to our company that are not in the handbook. So let's talk about essential policies. What has to be in the handbook? It's always good to have a welcome to the company, tailored to your organization, to introduce your employees to your mission, your vision, your history, what you do. Talks about the introductory period. Introductory periods are usually 90 days. Most companies have a 90-day introductory period. But employee benefit period's different. First of all, the longest employees can wait to enroll in employee benefits is the first of the month after 60 days under federal and California law, under the Affordable Care Act. So that's one thing that's different from an introductory period. And the second thing is that within the first 14 days of hiring an employee, under the Affordable Care Act, you have to give them a summary of their benefits. So it's different than it was before the Affordable Care Act. And I'll just give you an example. I just talked to a company recently that wanted to create a new handbook, and their wait time for employee benefits was a year. And that is not legal. It has to be first of the month after 60 days. It's been that way for the last 6 years, but obviously this company didn't know that, and they were just going to enroll some people in their benefits program after joining the company for a year. So you want to make sure that your introductory period is to introduce an employee to your company, and not a basis for employee benefits or other items. Fair employment policies. Every employee handbook required to have an equal opportunity section, an anti-discrimination section, anti-harassment. In 2018, now in California, you have to have a section in the anti-discrimination that speaks to gender identity, gender preference, and a lot of companies this year coming up would do that as an amendment. So they'll have an anti-discrimination section, an anti-harassment section, separated into an amendment and replace the pages that are in the handbook rather than write a whole new handbook. Reasonable accommodations for people with disabilities under the ADA, American Disabilities Act, anti-retaliation language, and also lactation policies. In California, it's required to have a lactation policy so that women who are nursing babies or expressing milk for babies have a place that is quiet, no windows, locked door, etc. Can't be a bathroom, and that needs to be in the handbook too. So those are some essential policies that have to be in the handbook. The other thing are wage and hour policies. How do employees account for their hours? Addressing off-the-clock work hours, if people do that and they're not supposed to. Falsification of time records. A report structure. Our employees here, they clock in and clock out on the computer with our time management system. But we used to use a paper system, which was turned into HR every couple weeks. And we found an employee that was falsifying those records and stealing time from the company. But we had something in written policy as to how you do things and how you account for it, and it wasn't followed and it wasn't accurate, and it was grounds for termination. Also in the handbook, you need to have information about meal, rest, and recovery periods, the timing and frequency of meal breaks, and the language is really important on meal breaks. And we may talk about that a little bit later. But someone is entitled, an employee is entitled to a meal break before 5 hours of employment start. So once they work for 5 hours, they have to have a meal break. But you can't say take your meal break after 5 hours, because that would be 5:01, 5:05, and that would be breaking the law. You have to say 4 hours and 59 minutes. So language is really important, especially in California with PAGA lawsuits. PAGA is the Personal Attorney General's Act, which allows an individual in California to act on behalf of the Attorney General and sue a company with the state of California receiving 75% of the claim and the employee or former employee getting 25%. And so timing and frequency of meal and rest and recovery periods are really important. They have to be duty-free and uninterrupted. And then premium pay for people that work longer hours. It's very important that you certify or have your employees certify that they've taken their meal and rest periods, that they have voluntarily not taken them. It's not taken a rest period, but meal periods they cannot voluntarily waive. So with the certification language, it's important, and that language is something that we want our employees to sign off on every pay period. It says that the following basically: I understand that I'm entitled to be relieved of all duty to take an unpaid 30-minute meal period whenever I work more than 5 hours, and a second unpaid 30-minute meal period whenever I work more than 10 hours. I also understand that I'm entitled to duty-free 10-minute rest periods for each shift of 3.5 to 6 hours. I certify that I've properly recorded above all of my time worked during this work period, including time worked during any breaks I missed, whether voluntarily or involuntarily. I certify under penalty of perjury that if any meal or rest breaks were missed, late, or shortened during this period, it was my personal choice, except for the following breaks, and let them write their breaks, sign it, and then you have them certifying that they got their rest periods, they got their meal periods, and if they come back later and say they didn't get them, then you have something in writing saying that they certify they did. Travel time policies. If people work for your company and they travel either by car or plane somewhere, and how you handle that. And then when your paydays are essential wage and hour policies. It should be in a handbook. We're going to talk about mandated leave policies for a moment. Originally, when I put this together, I just had what those leaves were, but I've decided to expand it a little bit and talk about the leaves. So if you have 50 or more employees, within a 75-mile radius of your company, you fall under the Family Medical Leave Act and the California Family Rights Act, or CFRA. So an employee that has worked 1,250 hours in the previous year can qualify for 12 weeks of continuous or intermittent unpaid leave for a number of reasons. Many companies require the use of vacation or PTO time, sick pay, only for the employee's own conditions. So when an employee is taking a family leave for their own medical issues, they can use sick pay. But if they're taking a family medical leave for a son, a daughter, a spouse, a parent, they can only use vacation or PTO policy. So an employer can require that or not, depends on what their philosophies are. Healthcare benefits are retained at the normal cost sharing. So if you have a company where you pay 80% of the employee health insurance and they pay 20%, when they're off for the family leave, they still have to make their portion of the payment. And then the question is, if they don't make it, what do you do and how do you handle that? And that's a leave question. And reinstatement absolutely is necessary unless their positions are legitimately eliminated during their leave period. Be very, very careful on that. The second is mandated leaves for companies with 25 and over employees. One is the Family School Partnership. This allows employees to take up to 40 hours a year to attend their children's events at school, counseling sessions at school, parent-teacher meetings, things of that nature. There is now a Victims of Domestic Violence, Sexual Assault, and Stalking. You have 25 or more employees to provide them a reasonable unpaid leave to deal with that, whether it's through the criminal justice system or counseling or something of that nature. You have to have a reasonable accommodation. Military leave of absence, usually up to 10 days, unpaid, but it's job-protected leave. And then alcohol and drug rehab leave. It can be unpaid, but it's a reasonable accommodation because alcohol and drug abuse is considered, rehab is considered a medical issue, and therefore falls under disability rules, and you have to have a reasonable accommodation. Other leave laws starting in California in January 1st of 2018 is the new parental leave law. Basically follows the FMLA rules, but for companies with 20 to 49 employees. Again, same types of rules that we had with FMLA, 12 weeks of unpaid leave for bonding with adoption, new birth, foster care placement within 1 year of that event. So somebody could say, well, I'm going to have a baby and I'm going to take 6 weeks leave, but then later in the year they can take 6 more weeks because they get 12 weeks of unpaid leave to bond in the first year. They can utilize accrued vacation or paid sick time or PTO. Employer maintains group health coverage, again, the same rules as with FMLA. And reinstatement is absolutely necessary. We get a lot of questions about this since it's a new law in January, but it's important to make sure that you are ready for these new policies if you have 20 or more employees. For 15 and more employees, you have Civil Air Patrol leave, organ donor leave, bone marrow leave, donor leave. A lot of times I see these missed in handbooks, because these came in the last 5 years and people haven't updated their handbooks. And then 5+ employees, which basically includes almost all employees, pregnancy disability leave in California, and FEHA disability law leave. For pregnancy disability leave or PDL, covered at the date of hire, up to 4 months of unpaid leave for a period of disability for pregnancy. This isn't bonding time. This isn't, I just had a baby, I'm going to take time off. This is if you have a medical condition that precludes you from working because you're pregnant. Medical certification of the existence of this disability is required. It may require sick pay being used because it is an unpaid leave. You can require sick pay being used. And reinstatement of a job is necessary. And then Disability Law Leave Act deals with reasonable accommodations for people with disabilities, and basically, if somebody is disabled and it falls under this California law, you want to make sure you have reasonable accommodation, that you ask them, what type of reasonable accommodation do you have that in constructive engagement discussion about how to handle things, and then let them have an unpaid leave. There's no specific time frame in the law, but, basically if, someone's going to have knee surgery and going to be out for 2 weeks, that that might be a reasonable leave versus somebody that was having another type of surgery or have another type of disability and may be out for a month. So basically, you have to have an engagement discussion with the employee and figure out what works. And if you don't have reasonable accommodations, it can have the end result could be a lawsuit. Other mandated leave policies, paid sick leave. In California, it's 24 hours, but in Los Angeles, it's 48. Other cities have other rules, like San Francisco has its own sick leave policy. Question is, how are you going to calculate it? Is it an accrual method, which is 1 hour per every 30 hours of work, or do they get the 24 or 48 hours of sick leave in a lump sum in January? The caveat here is that if you're not located in the city of Los Angeles, for example, Burbank, Santa Monica, Pasadena, San Fernando are examples of this, but your employees work, or some of your employees work in Los Angeles 2 hours during any week, they have to accrue at this paid sick leave of 48 hours, not at the 24. And also, you have to meet the minimum wage rules in Los Angeles, which are more stringent and higher than California. So the question becomes, can your accounting system, your payroll system, handle this difference in sick leave and minimum wage when they're in LA, or do you need just to pay them a higher amount and give them everybody a higher amount based on how your system works? Other civic duties are voting leave, jury duty leave, witness leave, and then military leave of absence, which I think we already talked about. Some leaves are at the employer's discretion. A lot of companies do not have a medical leave policy, and so that would be at the employer's discretion. We get phone calls all the time, at least once or twice a year. I have an employee that's got to go out for surgery. We don't have a medical leave. What should we do? Well, they say, what should we do? And then we ask if they have a medical leave policy in their handbook, and they say no. So, first of all, vacation and PTO is optional, but if you offer it, it cannot be forfeited. There's a trend to separate vacation and PTO and sick leave and get away from PTO. And the reason is that when somebody leaves a company, you're required to pay them their accrued vacation and PTO, but you're not required to pay them for their sick leave. So if you lump everything together into one policy, a PTO policy, and some employee leaves, you may be required to pay more money out than if you separated them. So there is a trend to separate vacation, and sick leave is different. Paid holidays. We have a number of paid holidays at really great employee benefits. Obviously, Christmas Day, New Year's Day, July 4th, Labor Day, things of that, Memorial Day, things of that nature. But we have something in our policy which is very common across the country, which is if an employee is asked the day before or day after a holiday, they call in sick, then they don't get holiday pay on that holiday because a lot of companies found that people would be off the day before a holiday. In my banking career of 25 years, I had an administrative assistant for about 20 years that we inevitably would be off the day before or day after a holiday. There's nothing in the employee manual about that, and I used to get ribbed a lot that she was off because it's the day before Christmas, day before New Year's, day before July 4th, but there was nothing in the handbook that said you couldn't do that, and if she had sick time or vacation time, she could do it.
So it's just one of those items that's in there. Bereavement, a lot of companies have bereavement leave. Normally, bereavement leave is like 3 days for a spouse, a child, a grandparent, a parent. But recently, we have a company that has people out of state, and the company had an employee that had a funeral that was out of the state of California and wanted to provide that employee with more leave time. So one of the things we suggested was they changed their bereavement leave policy to, if the funeral is in California, they get 3 days, and if the funeral is out of state, they get 5 days. Because they had 2 employees that worked out of state, we changed it to a funeral that was in their state, home state, and was out of state. So those are some of the policies that are discretionary. So let's talk about company expectations that are a lot of times in handbooks. I want to turn my phone volume off since it just rang. It's very common to have time and attendance paragraphs in your handbook, drug and alcohol policy, a policy against solicitation. I put Girl Scouts because inevitably during Girl Scout cookie campaign, employees come in and say, I want to sell Girl Scout cookies to the employees, or candy campaigns for schools, or holiday wrap, or things of that nature. So we have in our handbook that there's no solicitation of employees, and there's no distribution of materials. Especially during political campaigns, some employees want to hand out stuff, and we have its policies we have in our handbook. Conflicts of interest. Recently, we had an employer call us and say, we want to know if we can have a policy that says that an employee cannot work another job if they're working for us, and we basically said you can't preclude them from working unless it was a conflict of interest and they were working for a competitor or working in the same industry or what have you. Having a social media policy and expectations of the employer regarding social media. Lately, we're having many issues regarding, regarding companies where people are on their cell phones, they're on Facebook in the middle of the day, they're texting in the middle of the day, they're going to websites and buying things. So you have to have a social media policy. Dress code and grooming, I think we may talk about this a little bit later too, but make sure there's no gender identity issues in your dress code grooming policies. In other words, do not use the word female and male in your dress code. And then a policy regarding customer and client relations and how we handle our relations with our clients either in person or on the phone. Policies protecting the company and its personnel, driving and cell phone usage. If you have employees that drive, you should have a policy in your handbook about cell phone usage and about when they can use their cell phone, when they can't, texting while driving, things of that nature. If your company has any kind of surveillance, whether audio or video in your offices or your warehouse or your suite or what have you, you want to make sure that you have a policy in there that explains what it is. Policies regarding the use of company computers and the data that's on the computer and things that are on the hard drive or on the server. Relationships among employees. We had a client recently that called us. We talked about a man and a woman in 2 different parts of the company that were having a relationship with each other, and whether that was okay or not. And we first went and said, well, what does your policy manual say? Usually the first thing we say is, what does your employee handbook say? Confidentiality trade secret policy. As I mentioned, it can be in the handbook, but it can also be a separate agreement. Social media policy, workplace violence prevention. Nowadays, with workplace violence on the rise, to have a paragraph in there about workplace violence. Supplemental documents, as we mentioned before, confidentiality non-disclosure agreement, an arbitration agreement, social networking policy could be a separate agreement, business expenses and client marketing policy, Those can be in a handbook or separate. Travel time, wage deduction authorizations. You really can't deduct legally wages, anything from an employee's wages without their written permission, and that would include their portion of health insurance, medical, dental, vision, 401k, voluntary products from Aflac or Colonial, anything you're going to deduct from their wages except a garnishment. You have to have a written agreement up front. Uniform agreement if you provide uniforms for them, or tools. If you have a situation where employees use their own tools or company tools on jobs, what that policy is. Some of these can be in a handbook and some are separate agreements. We just did a handbook for a high-tech company in Culver City, and they wanted their confidentiality agreement and their arbitration agreement in the handbook, which was put in. We'll talk about common handbook mistakes right now, and one of them is the one-size-fits-all policies that are not tailored to your company's needs. Recently, I heard from a labor law firm at a seminar I went to through the Professions of Human Resource Management, the LA chapter, Woodland Hills, that a company had a lawsuit against them, and they provided their handbook as an example of what the policies were, and it was thrown out. The handbook was, because it was too generic. It wasn't customized to the company, and it didn't work. I recently talked to a company in Van Nuys that has a handbook, and I said, well, how did you get your handbook? How did you create it? Did you use a lawyer or an HR consultant? I said, well, I worked for a Fortune 500 company, and I basically used their handbook and just made it for ours. So now we have a Fortune 500 company handbook for a company with 20 employees, and my guess is that the guy didn't do it right, and there's things in there that don't pertain to their company because they're too small. The second most common mistake is failing to consistently implement your policies. You have something in your policy, and then you don't implement it. You don't follow it. We talked about culture a lot in my CEO group that I'm in, and we talk about, your company culture is what you permit, not what's in your handbook. It's what you allow to happen. So if you have a handbook and there was a policy about social media, but you let employees use their cell phones and they're on Facebook in the middle of the day and you don't deal with it, you're causing a problem. It's what you permit to happen. So you want to make sure that whatever policies are in a handbook that you're following. Another common problem is addressing federal requirements and not California requirements, and as of the past few years, certain municipality requirements. As I mentioned earlier, the City of LA sick leave policy, City of LA minimum wage policies. There are approximately 27 cities in California that have their own policies that may pertain to employees. And if you're located in one of those cities, you got to make sure you have it in there. Creating policies that contradict the handbook, or vice versa, which is not necessarily failing to implement policies, but you have a written policy in your handbook, and then you have a memo that says we're going to do this on this subject. And it could be computer backup. It could be social media. It might be some other policy that is in the handbook, and then you create a new policy that contradicts it and you don't realize it. And then the other thing in handbooks that sometimes get you in trouble is when you promise, in your handbook, we're looking forward to you having a long career with our company. Anything that would promote or promise a permanency of jobs, when every handbook has an at-will section, is important to make sure you don't have. These are common mistakes. Attendance policies, common mistake. Avoid language that may appear discriminatory. For example, absenteeism and tardiness is a burden on the company and will not be tolerated. Well, what happens if somebody has a situation where it's a physical ailment or illness or disability that creates the absenteeism or tardiness, and you say it won't be tolerated, then you have a discrimination problem. So it's better to put in language that says absenteeism or tardiness, even for good reasons, is disruptive to our operations and interferes with our ability to satisfy customer needs, which then allows that reasonable accommodation. Tardiness in your attendance policy. A lot of times people have in their attendance policy that a tardiness is 1/3 of a sick day, and if you have too many tardies, they equal a sick day, but then they don't follow it. Job abandonment. What happens if you don't have a job abandonment section in your policy and somebody doesn't call in or doesn't show up for 3 or 4 or 5 days? What do? So you have to have a section in there, which usually is 3 days, although we have a new client that in their handbook they put 5 days, which was their prerogative. But if you do have a job abandonment and it says 3 days, you got to follow it. And you can't discriminate against an employee versus a different employee. Alcohol drug policies. First thing up there, under the influence versus in your system. Basically, with California starting January 1st, where marijuana is permitted in California, but not necessarily at work, but it's okay to use it. It's good to change your language from under the influence to having drugs in your system, because under the influence is kind of hard to determine, but in your system you can obviously determine that. Searches, but there's no reasonable expectation of privacy in desks or lockers. Employees may be subject to searches. If you do drug testing, whether you have a reasonable suspicion or it's post an accident, if you're in a machine shop or you have an accident that might be work comp related and you want to test for drugs, and then random tests. So basically what you want to do in your handbook is list all prohibited conduct. You can't be under the influence. We're going to change that to in your system. You can't have drugs or alcohol in your system during work hours that affect your ability to perform work on behalf of the company, something of that nature, and make sure that you follow that. If you believe somebody is under the influence, or as a new language would be in your system, and they're having problems at work and you think they might be high, that you deal with that versus letting it go, because once you let it go, then you created a condition in your company or a culture that you're not following your own written rules. Anti-harassment is just broader than sexual harassment. You have to list all the protected categories, which now includes gender identity, gender expression, things of that nature. But the policy needs to allow employees to report to someone other than their supervisor. And most anti-harassment policies permit them to go to HR, and also has listed the Department of Fair Employment and Housing in California and their phone number and website. Make sure that supervisors report all complaints, that you start remedial action and investigation, that you follow your written policies. Anti-retaliation for whistleblowers and participants. It's interesting, if you look at the anti-discrimination claims in California during the last year, we'll say 2016, there were 17,000 plus allegations of discrimination that was given to the Department of Fair Employment and Housing. Of those 17,000, 12,000 were in the anti-retaliation sections. So it wasn't race, national origin, what have you. The biggest category was retaliation. So it makes sure that if somebody is reporting a harassment of whatever, hostile work environment, sexual harassment, bullying, that you deal with it immediately, and that you don't retaliate against the employee for doing that. Discrimination policies also extend to third parties. Vendors, visitors to the company, customers, clients of the company, anybody that walks into your offices or your company's location or your suite, or even on the phone If they do something that is not appropriate and an employee tells you that, you have to deal with that under the law. So very important to have that in your policy manual. Equal opportunity employment, obviously. Reasonable accommodation for disabilities, we talked about that before. Meal period policies. We talked about meal and rest periods earlier. This is a little bit more regarding it. Except for salaried exempt employees, it is our policy to provide and afford employees who work more than 5 hours in a workday with an uninterrupted 30-minute meal period, free from all duty, no later than the end of the 5th hour. So again, you're saying no later than the end of, rather than, at the end of the 5th hour, 1 minute or 5 minutes over or whatever. And rest periods also, company provides all employees with the opportunity to take a 10-minute break for every 4 hours of work, which should be taken so far as practical in the middle of each work period, not at the end. We've had phone calls from clients that say, hey, I have an employee that wants to skip their meal period and just take off every day a half hour early. Well, that's really nice. You want to help them and you want to let them do that, but however, it's illegal, and you can't let them waive that. If you go to the meal period policies in the state of California and you look closely at what's permitted, there are certain instances where you can have an agreement with an employee to skip a meal period or handle it differently. One of them would be drivers for your business. If you have truck drivers or you have drivers that are out in the field delivering things to clients or picking things up, they can have special meal and rest periods. But people that work at your company, you can't do that if they're in the offices or in your warehouse or in your office building. So rest periods, here's the little breakdown. 3.5 to 6 hours, they get a rest period. More than 6 to up to 10 hours, they get 2 rest periods. And more than 10 hours up to 14, they have 3. Very common. Make sure you follow the rules, have a schedule, let people know what there is. Travel reimbursement policies. Cell phone usage. In California, there's court cases regarding cell phone usage. If an employee uses a personal cell phone for business, you have to reimburse them, regardless of whether it costs them money or not. So if your employee has a cell phone and they pay $50 a month, and all calls are free and texts are free and internet's free, you still have to impute what that cell phone usage would cost, and you have to reimburse them. You can have a policy that says you can waive the right to reimbursement if they don't submit expense report in a reasonable time frame, and you can't have unreasonable mileage reimbursement rates. Every year, the IRS adjusts their mileage reimbursement for employees that drive. It went down in 2017. It's going up 50 cents a mile in 2018. But make sure you have that policy and you follow it. Vacation policies. Biggest issues we see are improper accrual rates, improper caps. Companies that don't cap their vacation at all, and people can end up with 3 weeks, 4 weeks, 10 weeks, 20 weeks because they don't take their vacation, and then when they leave the company, you're required to pay them that. Improper utilization of paid sick leave for vacation purposes. So the important part is that you accrue your vacation and your sick leave properly, that you follow those rules that are in your handbook. What most companies are doing nowadays is they're capping vacation. So I think we provide 5 days of vacation a year. After 5 years, you get 2 weeks of vacation. But we cap it so that if you don't take vacation, you can roll it over, but it can never equal more than 2 times your annual accrual rate. So it caps out at 2 weeks. Unless you've been here longer than 5 years, then it caps out at 4 weeks. And therefore, if they leave the company, you limit your exposure. paid sick leave, failure to recognize proper accrual rates, place the balance on the pay stub. So let's talk about pay stubs for a moment. In next month's webinar, which will be a labor law update for 2018, we're going to talk about what has to be on a pay stub, because there's a recent court case where a employer is being sued under the PAGA laws and is hoping for a settlement under $1 million because the Court of Appeals said that it can go forward. And it has to do with information on the pay stub. So on the pay stub, you have to show the accrued sick leave, what is available and what has been taken. And that's one of the things that has to be on the pay stub. Another thing, which is getting this company in trouble, is not having the last 4 digits of the employee's Social Security number. They outsourced their payroll to a payroll company, one of the 2 big ones, which was either ADP or Paychex, and the 4 digits were missing, and the employer claimed that, well, God, I outsourced it, and I relied on them, and the court said, that's too bad. It's your responsibility. So proper paid sick leave on pay stubs, failure to outline reasons for taking leave in your handbook. We talked about earlier why you should take leave. What are the reasons, some of the leaves that you might have. And failure to include language in your PTO policy about sick leave. So very important. Drug testing policies, we talked about that a little bit before. Having a blanket post-accident testing provision is okay. Failure to outline what reasonable suspicion is. Using the term illegal drug use or illegal substances, which precludes marijuana in California starting in January 1st, but also prescription drugs. So if your policy talks about illegal under the influence or now in your system of illegal drugs, but they're taking prescription drugs that impairs their ability to work, your handbook doesn't say it, so it's a problem. Not treating a rehab stay as protected leave. We talked about that earlier, that a rehab stay for alcohol or drug abuse is considered a protected leave and falls under the disability areas, and you have to have a reasonable accommodation. And companies that improperly use random drug testing, and in their handbook says we can have random drug testing but doesn't either follow it or explain what that means or what have you. Policies that violate the National Labor Relations Act. These policies are important to have, but if they're not carefully drafted, they can violate federal labor laws. Most of the time that is in regards to union organizing, at-will disclaimers, code of conduct disclosures that might infringe on the right to organize or engage in other protected conduct. But you got to make sure your policies regarding solicitation and non-solicitation and social media and confidentiality isn't falling into a problem with the National Labor Relations Act as it pertains to labor union activity for the most part. Additional policies, we talked about grooming and dress code earlier, but avoid gender-specific requirements, provide for reasonable accommodations. Discipline, code of conduct. Let's talk about discipline. A lot of times people say, well, we have progressive discipline. So we have a verbal counseling, and then we have a couple written warnings, and then we have a written warning with termination language in there that says this is your last written warning. The next time you may be terminated. But what happens if you don't exclude certain things like stealing? If an employee steals, whether it's company equipment, whether it's out of an employee's purse or desk or what have you, if you have something in your handbook about progressive discipline, but you don't say that it excludes certain things like theft, then you can't terminate somebody for stealing. Non-exhaustive list, which says we're going to discipline you for certain reasons, but you don't list out what those reasons might be. And you have to clearly identify prohibited behavior. A, B, C, D. You can't do these items. So that's kind of important to make sure you do. I ran into a problem recently where a client called one of our people and said that they wanted to fire somebody because of something that happened at the company, but they have a progressive discipline policy, and their handbook hadn't been updated in 5 years, and there wasn't proper language that would permit them to do that. And so we said, well, you better speak to a labor attorney and figure out what you can and can't do, because your handbook isn't clearly stating what's possible. And lastly, I want to talk a little bit about the implementation of handbooks. If you have a handbook, you got to make sure that people read it, that you conduct meetings about it, that if it's done online, that you send them an email saying that our employee handbook is now online, that you can read it and acknowledge it, sign and acknowledge the handbook. There's recently a question that was asked in an HR question and answer website that says, I have an employee that refuses to sign acknowledgement of the handbook, but they don't agree with all the policies in the handbook. They don't want to sign it. And the answer to that was, well, first of all, why would you want to have an employee work for you if they weren't going to follow your policies? But basically, the acknowledgement should say something to the effect of, I acknowledge that I've read and understand and will behave under the policies of the handbook. Behave is not the right word legally, but I think you get the drift, which is you're acknowledging that they've read the handbook, they understand the provisions, and that they agree with all those provisions, and you put that in the personnel file, and you got it. I read something recently in an HR publication that said that 80% of employees never get past the first 10 pages of a handbook. So what you might do, and you know, I think it's a good policy, is that maybe every once in a while at an office meeting or an employee meeting that you take a few sections in the handbook and discuss it. Things that might be important that they might violate, like social media policy or cell phone use at the company, things of that nature. You don't have to provide employees a hard copy. It can be a soft copy through email or on an employee intranet site or an online HR site. Translating the handbook, last item I want to talk about. In California, if more than 10% of your employees predominantly speak a different language, you have to translate everything you give them into that language. And there's 17 languages in California that are part of that. So those 17 languages include Vietnamese, and we have a client in Orange County that has half of their employees speak Vietnamese, and all of their corporate documents and all of their handbooks and anything they give to their employees is in English, and that is against the law. They need to make sure that they have it in another language. So I point that out because it's an important thing in California, and if they talk amongst themselves or talk to other people at other companies that are friends, and they find out that it's not, they're not getting it in their primary language, that they may find an attorney and decide to sue, and you have no recourse in California. So lastly, we believe that if you have any questions, we're the best source regarding HR, Affordable Care Act, ERISA, HIPAA compliance, compliance with city, county, state, federal labor laws. If you have any questions, please give us a call. Give your employee advocate account manager a call. Give our new HR area, Brent Yarkin, who heads up our HR practice, a call. The bottom line is we're here for you. We're here to make sure that things are being followed properly, that you have your handbooks in place, and that you don't open yourself up to litigation. Just a brief update before we close for the day, and that is that in January, on January 10th, we're having a labor law update for 2018 for all the new labor laws in California that affect employers. And then in February, we're going to have Robert Grossman and Karen Bublis provide a webinar on employee engagement and morale in companies, and that will be in February. So thank you very much for attending the webinar today. Look forward to hearing from you in the future and seeing you on January 10th at the Labor Law Update. Thanks, and have a great day.